Judge, there's a few moving pieces today, and I'll do my best to kind of summarize the reasons for which we are here. There was a previous order entered by the Chancery Court on February 5th, 2026, setting some temporary support. At that time, Mr. Thomas was represented by Jacob Mathis, and Mr. Black represented Mrs. Thomas. A motion to set support, temporary support, both spousal and child support, was filed by Mrs. Thomas, and that notice was sent to counsel at the time for Mr. Thomas. At some point in between the filing of that motion and the hearing for that motion, there was a breakdown in communication between Mr. Thomas and his previous counsel. Mr. Mathis had filed a motion withdrawal that was set for that same day as the temporary support hearing. Mr. Thomas, I believe if the court were to take some testimony today, would state that he didn't have notice that the temporary support hearing were set for that day, and consequently he did not appear at that hearing, Judge. His attorney at the time was allowed to withdraw, and then the court proceeded with setting some temporary support, and I believe the court set temporary support in the amount of $1,500 per month.
And that was a different judge than me.
That was Judge Wallace, Your Honor, I believe. And I wasn't here for that hearing either. And ultimately, so the first motion I filed is a motion to reduce or set aside the temporary support order. And that's just, I don't believe the court that day. I can't speak to what the court did or did not hear. I wasn't there. But based on my understanding, the court set that support without inquiring into my client's ability to pay. And that's all I'm asking the court. This was I believe a 17-month marriage before the parties separated. There was one child alleged born during the marriage, presumed to be the father's. The father disputes, and we're going to get into the DNA issues here in a moment. There's one child born at the time that hearing took place, and another child that the mother was pregnant with when that hearing took place. So there's two alleged children of this marriage. The court had ordered some DNA testing to occur that hadn't occurred yet.
Let me interrupt you and just simply say, what my concern is that Judge Wallace conducted an evidentiary hearing on the February 5th, 2026 date, and following that made findings of fact that served, the findings of fact served as the basis for his making the order in the case. Now, for me to change that order would basically retry the entire temporary motion, and it seems to me that the more appropriate matter would be to reset this in front of Judge Wallace, who is here next month, and would be able to consider your motion to set aside or to modify his prior order.
And if Your Honor's inclined to do that, I'd be okay with that. I just, he didn't have, no matter what Judge Wallace did or did not hear, we know Mr. Thomas was not present, and there was no inquiry in regards to his ability to pay at that time.
Well, I'm disinclined to go behind what another judge has found and ruled upon, because there may be some other factor that, that wasn't made apparent to me. And you had Judge Wallace's calendar.
That works for me. Salmon depositions. Looks like I'm available June 16th.
Well, I think I'm sorry for the inconvenience, but it clearly seems to me that Judge Wallace needs to consider a motion to set aside or to amend or change the order that he did after an evidentiary hearing. So we'll reset you for June 16th.
Would Your Honor be inclined to entertain the other motions in this matter?
Well, if you're going to go in front of him on any of them, I think you need to hear him. He needs to hear them all. So.
And there is an emergency motion we filed for immediate relief that's set for today. Mother there was a child, she was pregnant at the time of the last hearing. This child's since been born. Without any notice to father, this child has been removed from the mother, placed in an adoptive family in Colorado.
I did read that in the file.
Father was served Friday with a petition for adoption. Father's got 35 days, according to that Colorado summons, to file documents in Colorado contesting the adoption.
Well, let me ask this question. There was an order for DNA testing. Is that because there was some question whether he was the biological father?
With respect to both children.
And if he is the biological father of this child that's now being put up for adoption, obviously he has a vested interest in objecting to that. We'll go forward on that particular issue because I think there is an emergency basis. Why has there not been the DNA testing?
And that's why we filed the motion to review DNA testing. Again, Mr. Thomas was represented by previous counsel. They had entered an agreed order to participate in the DNA testing. The order required the testing to be scheduled by the father. There was some exchange between counsel about setting up the DNA testing. Mr. Thomas notified me he was going to any lab now. There was no specific place set forth in the order to do the DNA testing. Mr. Thomas noticed me. He was going to any lab now. I subsequently noticed opposing counsel. There was no objection made to that. The DNA testing was done and paid for by Mr. Thomas there. And then shortly thereafter, mother stated that she would, I guess, not be able to do the DNA testing at any lab now and referred us to an email that was previously sent over saying, I believe it was another DNA lab North America would be more convenient for her. So it just seems like every time we get close to getting DNA testing done, mother is trying to interfere with that. Now we have a child in Colorado. I don't know how we do the DNA testing with the baby in Colorado. Mother has voluntarily taken this child or let this child be taken. I believe she relocated to West Virginia due to abuse allegations that were prior to my time. There was an agreed order I saw in the file entered between Mr. Thomas's previous counsel, Mr. Black, allowing her to relocate. The child, I believe, was born there in West Virginia, and she subsequently has taken this child and placed the child in Colorado without any notice to the father. The first time he's heard of this child being in Colorado with these pre-adoptive parents was Friday when he received service of this petition. So we had filed the motion to review DNA testing today because we're having an extreme difficulty in getting this done. This order was entered, I believe, 2 or 3 months ago, maybe even longer ago than that, and we still don't have DNA testing done. I don't know how we accomplish it now with a child that's in Colorado.
Parties are before this court, and therefore, one option is that I simply order that the child, the mother, and the father all appear at a lab here in Tennessee, submit to the DNA samples being taken, and then we go from there.
And that's what we're asking the court for today, is enter a more clear order directing the parties regarding the DNA testing. Judge, with respect to the emergency motion for immediate return of the minor children, both of them, again, there's an issue with paternity that should have been resolved. It's not. I hope we can get that resolved very quickly. But mother has taken this child, and I would submit that the children are subject to this court's jurisdiction. I know the child wasn't born here, and opposing counsel might make some UCCJA arguments about it, but I believe this court has jurisdiction over the custody of these children. There's a pending divorce. This happened during the pendency of this divorce proceeding, and mother relocated voluntarily and is now attempting to just go behind the father's back and have this child adopted. If this is father's child, he absolutely asserts a right to custody. He wants to be the father. Mother surrendered and voluntarily terminated her parental rights. That's fine. Then the court needs to enter a 365-0 plan awarding custody to the father because he wants to be a father if he is indeed the biological father. So we're asking the court today for some immediate temporary relief, and that brings us to the other minor child in mother's care, custody, and control. We don't know. There's an order of protection that was entered and subsequently appealed by father that the court's reserved for final hearing.
And where is that? Is that in this court or is that in a different court?
It was originally in general sessions. They had a hearing, is my understanding, and then that was entered and appealed. So there's still an order not allowing Mr. Thomas to have contact. And he cannot have contact with Scarlett Thomas. I believe she's almost 2 or 3 years old now. But we're asking the court to return both of the children to father. We don't know what mother has put a child up for adoption. We don't know where Scarlett's located. We don't know how she's doing. We don't know if mother's a fit and proper parent to have sole custody of Scarlett. She has given the other child up for adoption. And so we're asking the court for a more clear order regarding the DNA testing, to order the parties to have DNA testing completed within a specific amount of time. And we're asking the court to enter an order to have baby Thomas brought back from Colorado to Tennessee, and to have Scarlett Thomas return to the father. I think it's a threat of irreparable harm that this child's outside of not only this state, but in Colorado. Mother, by the attachment with what father was served on Friday, it is clear mother has consented to the termination of her parental rights. So we're asking the court for that emergency relief today.
Your Honor, I do have a response on both of those. Would you like me to tackle the DNA testing or the emergency?
Let's start with the DNA testing.
Your Honor, so the DNA testing, so my recollection of events and what has happened is that there was an agreed order between Ms. Thomas and Mr. Mathis, so Mr. Thomas's prior attorney. That was last year. Subsequently, Mr. Mathis withdrew. There was no contact between us. Had to hire a personal process server to actually serve Mr. Thomas some documents to try to find him. At that time, Ms. Thomas was absolutely willing to do DNA testing, and there was just nothing until very recently. There was a renewed push for the DNA testing, which Ms. Thomas is willing to do. I will point out to the court that Ms. Thomas is in another state due to domestic violence, which Mr. Thomas was convicted of in General Sessions Court by plea of guilty. She is in another state due to violations of an order of protection for multiple house break-ins, for following her to a medical facility and taking her vehicle. These are the reasons that Ms. Thomas is out of state. And so in an effort to preserve Ms. Thomas's undisclosed location, a essentially secret address, we were trying to coordinate DNA testing that could occur both locally here and where she was located. And that is why I proposed LabCorp. My understanding is when I had proposed that is the testing location we were going to use. And then I received communication that is not the testing center that was used. And then at this point, we reached an impasse.
So are you saying that LabCorp is available to do the testing both for Mr. Thomas here as well as for your client wherever she may be living?
So here as in Hendersonville, Your Honor, and where my client is living. That was our proposition. I will say that while I have nothing to give the court at this exact moment, my understanding is that the newborn child of this marriage is located in Denver, Colorado, which I found out about, to make it clear to the court, found out about Thursday evening.
Who is the father of that child?
So Ms. Thomas is going to say it's Mr. Thomas. I believe Mr. Thomas wants the DNA testing.
So we're going to, the order went down only as to Scarlett Thomas.
That's my understanding.
And there was a DNA request as to that child, and now we have another child born, and Mrs. Thomas says that is Mr. Thomas's child.
Yes, Your Honor.
And she has placed that child for adoption?
That is my understanding. I will say on Ms. Thomas's behalf that there appears to be some evidence that this was an understood plan between them when they found out that the child was going to be born. That actually, according to Ms. Thomas and perhaps some messages she would admit at hearing, Mr. Thomas has spoken to the adoptive parents before, that there was some dispute over whether they were going to raise this child or not. And at this point, Ms. Thomas could speak for herself.
Well, if there is an afterborn child that was born while this case has been pending, then this court has jurisdiction over that child regardless of what has been filed in the state of Colorado.
Well, Your Honor, I will say simply for the fact that I do not want to waive any jurisdictional issue, and I've not had time since this was an emergency order filed. I would like to file the detailed response. I will raise a jurisdiction issue just to preserve it under the UCC JEE. It's not so clear which is the home state because the newborn child, if we parse them apart, right? The older child, absolutely concur with Your Honor. The youngest child, there may be some dispute over what is the home state. I have been informed that the state of Colorado has decided that they have jurisdiction and they are proceeding with this adoption proceeding. Again, I'm in candor to the court. It's a complicated issue to me, and I would need to file a brief and research that to give a response. But I do want to raise the objection that for the youngest child may not be the home state. But besides those things, Judge, I would also say
You cannot divest this court of jurisdiction
Understood.
by sending a child that is one of the children of these parties with a pending divorce action where custody of one child is already at issue, and then send one of the children that is alleged to be the biological child of Mr. Thomas. You cannot then send that to another state, that child, and defeat the jurisdiction of this court to make a custody determination. So I just want to make that clear that this court's opinion is that this court has jurisdiction over both children if they are in fact the children that were born of these parties. And that is what I'm told by both of you today. So I'm of the opinion that Mr. Thomas needs to contest the adoption, and if he does contest that adoption, I'm going to put an order down that's going to require both of the children to undergo DNA testing. How that is accomplished is going to be up to you and your client. That means that she's going to have to ensure that that child is coming back and is tested. Now, we had a case not too long ago in this court where there was a woman who claimed to be a biological heir of an estate, and she lived in Washington State. There was a method by which she used a laboratory in the state where she lived to obtain her DNA sample. Then that was compared to DNA samples that were tested here in Tennessee. It would seem to me that's what's going to happen here. You're going to have to obtain a DNA sample from this child in Colorado and a DNA sample from your client and her child wherever she is living. And then a sample will be taken from Mr. Thomas here at LabCorp. And all of those are going to have to be analyzed by LabCorp to determine the paternity issue. The order that this court puts down is that this court maintains jurisdiction over the parties and both minor children who have been represented to this court by counsel to be the biological children of these parties. And that the adoptive court in Colorado, obviously this is going to be an issue for the appellate courts if it goes through as a contested matter, but I think we got to first resolve if this child in Colorado is Mr. Thomas's biological child. If it's not, then there's no issue. If there is, then he has to take the steps to contest it there in Colorado. He cannot ignore the Colorado proceeding and rely upon this court's ruling, because Colorado may say, we don't care what Tennessee does. We're holding that we have jurisdiction. I'm ruling, I don't care what Colorado says. I'm saying I have jurisdiction. So,
Understood, Your Honor. On the emergency petition, essentially to return, I guess, both children to Mr. Thomas, on Ms. Thomas's behalf, I would also say that,
now excuse me for interrupting, I apologize. Is there an order of protection still in full force and effect?
yes, Your Honor, there is. There's also a pending contempt for those house break-ins. That is also in effect.
And under that original order of protection, what provision is made for I don't have the order of protection in this file that
I can provide it. I believe Mr. Bellamy had said that Scarlett is listed under it, which is our oldest child. I did not see that, but I can provide it.
Well, and my question, of course, is what, if any, provision is made in that order of protection for the one child that's there that we know, Scarlett.
So I'm looking at the petition, and just looking at the petition, I do not see Scarlett listed on the petition, but it was the
Thank you. This is the temporary order that I've been handed. And then you're saying that there's already been a hearing on that temporary order of protection and it was extended?
Yes, Your Honor.
And was that in circuit court or general sessions and then it was appealed?
It was appealed, and the appeal was not heard, and by agreed order, it was set off.
It was reserved for final hearing by
That's
previous
correct.
counsel. So it's my understanding the order of protection that was entered by the General Sessions Court is still in effect, and Mr. Thomas has no contact with either the petitioner nor the minor children covered under the order of protection.
Well, I'm looking at the order that was entered in this court after the hearing on February the 5th. In paragraph 2 of the findings of fact is the wife testified that she had been married to Mr. Michael Thomas, husband, since 2024. The wife testified the parties have a 10-month-old daughter born of the marriage, Scarlett Thomas, and that she was also pregnant with the marriage's second child, which is due in early March. So according to Judge Wallace's finding, and that's the order that you're asking to be set aside, he made a finding based on her testimony that that was in fact the child of the marriage that's now in Colorado sought to be adopted. And it goes on to talk about these findings of fact. Nowhere in that order does it specifically order anything other than temporary spousal support. It doesn't put an order down regarding the temporary parenting plan or custody of the minor child.
That's my understanding as well, Your Honor. If I can say, though, we would object to Mr. Thomas having the children, and there's a lot of reasons to that maybe perhaps Ms. Thomas could add with testimony, but she's been the primary caretaker.
Well, Mr. Thomas filed for DNA testing. I'm not going to grant him custody of children that he has a question of whether or not.
Yes,
When I
sir.
started practicing law, that was a factor that if a parent, a father requested DNA testing, that was a factor the court could consider among all the other factors in determining whether or not he ought to have, what type of visitation or custody or whatever. So if he's questioning whether this is his child or not, then I'm not likely to say those children have to come back and live with him, especially in view of the fact that there are orders of protection in place.
Pending any questions, Your Honor, I have nothing else to add.
This is a mess. And I'm going to do one thing. I'm going to check with Judge Wallace. It may be better if I heard this case and through its, I don't really want to, but it may be better if I can do it. We checked on your availability on the 16th, is that correct?
Yes, Your Honor, I'm available.
But what about the 15th?
I can check.
Looks like-
What did we set on the 16th? Anything for me? Yeah, I can give you the 16th.
16th would work for
everything.
me, Your Honor.
I'd like to just check with Judge Wallace. If he doesn't have an objection to me hearing the motion that you filed, then I would suggest we hear everything on the 16th. And if Ms. Thomas, I think we need to get this DNA testing done as soon as possible.
Understood.
Judge,
So we're talking about June 16th to hear everything, all of these motions, and between now and then, I want the DNA testing performed on both Scarlett and the child that's in Colorado. That DNA testing will be performed by a sample taken by Mr. Thomas by LabCorp here in Hendersonville, a sample for Mrs. Thomas and the minor child Scarlett in the state where she resides by LabCorp, if there is one there, and by LabCorp in Colorado where this minor child is. It would be Mrs. Thomas's obligation to ensure that the child's sample is taken and that proof is obtained from Colorado of the validity of the identity of that child. In other words, I tell you this story that we had a well-known ne'er-do-well down in Humphreys County who is a member of a famous music family down there. And he was hired, or rather he was sued for child support. Back in that day, set you up with the father and the mother and the child all went to get the blood test done. So came back negative, and the mother just was irate, could not believe it. And anyway, they apparently took a picture of the father and the child and the mother. It wasn't the defendant. He had sent one of his buddies to go have sit in his stead, and of course it came back it wasn't. And later it was his child, so they had to redo it. What I want is to make sure that that child is identified in the state of Colorado sufficiently by whatever means, photography or whatever, that we can ensure that Mr. Thomas knows this child that is being tested in Colorado is in fact the same child that we're having questioned. And so I think we do that DNA testing, and I'd like to have that done within the next 10 days on all parties, and then we reset it for June 16th, and hopefully we'll have the results of that at that time. And I will check with Judge Wallace to see if he has any objection to me considering your motion to modify his order, and then we'll go from there. All the other motions, I would think, need to be heard on that same day. I realize it's an emergency type situation, and that's why I'm giving you the June date. I'm supposed to be in Humphreys County that month, so.
Appreciate it, Judge.
Anything else?
If I may, Judge, and this kind of gets into temporary support, I don't want to do that.
Well, he pays for his test, she pays for her test, and he's the one who's requesting the testing, so it's going to, understand that I'll consider that at the next hearing, but he's going to have to bear the cost of the test itself. She will pay for the test for herself and the two children. He will pay for his test and the performance of the actual DNA testing.
So we'll go with an itemized list of what the charges are for the test, and
Correct.
she's responsible for herself.
Right.
Understood, Your Honor.
Otherwise, the other option you have is tote that child back from Colorado, bring it here, and have all three of them, all three, your client and the two children, tested at LabCorp in the state she lives in.
Understood, Your Honor. And I'm going to ask just one clarification and request to this court. If those are determined to be Mr. Thomas's children, can Ms. Thomas be reimbursed for her cost of the test?
If they are Mr. Thomas's children,
Yes, sir.
she can make application for reimbursement at that point in time.
Understood.
Normally, if someone contests that being their child, and it turns out they are, then they requested the DNA, they have to pay for it in the end result. But as was pointed out, if he's incurring a great deal of expense to fight an adoption of a child he never consented to being adopted, then that may be a factor as well. So.
Understood.
All right. I'm of the opinion that we have it all heard on the 16th, and we will sort it all out to the best of my ability at that time. So we'll stand adjourned. Thank you.
Thank you, Judge.
You going to draw the order?
I'll prepare an order, Judge. Thank you. Judge, we were previously here on May 18th, and the court had put down an order. There were several motions on the court's docket that day. I'm not sure if the court recalls.
I do recall.
The court had put down an order saying the court would confer with Judge Wallace to see about taking over this case. I believe a motion prior to Mr. Thomas retaining me, and now Ms. Thomas has gotten new counsel, but there was a motion that occurred. I believe Judge Wallace heard it on temporary support. We had filed on behalf of Mr. Thomas a request for the court to review that, as he was not present when that was established. Beyond that, the court had ordered the parties comply and get the DNA testing done. That has been done. Mr. Thomas is indeed the father of these two minor children born during the pendency of the marriage. We also, the court had entered an order stating that this court had jurisdiction over those minor children in regard to the emergency motion for temporary custody that Mr. Thomas had filed due to the adoption with the newly born child. And I think the court ultimately left it at the court would confer with Chancellor Wallace about taking this matter over.
I did confer with Chancellor Wallace, and he has no problem with me hearing this case and doing whatever needs to be done. So.
Understood. And so I think where we're at, Judge, we have agreed, Mr. Kirby is now representing Mrs. Thomas. I believe he filed a notice of appearance in this matter last week. We have agreed I will give Mr. Kirby some time to get up to speed on the temporary support issues. I think we do have to address today the immediate motion, the emergency motion for return of the minor children. Mr. Kirby filed a response to that on Friday, citing the UCC JEA and how this court needed to reconsider its previous ruling on it having jurisdiction over that minor child. I don't know if the court wants to hear testimony on that today or just argument.
I'll hear whatever you want to hear. So.
And I really think factually it's undisputed. The child was born in West Virginia. There was an order of protection entered by the General Sessions Court here in Dixon that included one of the minor children on it. The baby Thomas had not yet been born. Mother relocated pursuant to an agreed order. That order of protection was appealed. The parties reserved that for a final hearing. The new minor child was born in West Virginia. Not entirely certain on the facts. The child at some point went from West Virginia, I believe the day she was born, and relocated to Colorado with pre-adoptive parents. I know it's mother's position that this court does not have jurisdiction under the UCC JEA to make an initial custody determination. However, father would aver that under 36-6216A2, this court does have jurisdiction to make that initial custody determination. I'm sure the court's familiar. It's kind of our argument that there is no home state of this child. Home state is defined under the UCC JEA as a child that's living with a parent or a person acting as a parent. If the child is under the age of 6 months, it's the state in which the child's lived from birth with any of the persons mentioned. So that would be a parent or a person acting as a parent. Child's in Colorado, not with a parent and not with a person acting as a parent. The person acting as a parent is defined under that statute. It's our contention that the pre-adoptive parents in Colorado are not persons acting as a parent. So it's our contention Colorado is not the home state. That leaves West Virginia. There's no actions pending in West Virginia to our knowledge that we've been notified of. Also, mother under the UCC JEA has a continuing duty to supplement to this court in a divorce proceeding under the UCC JEA if anything is to change during the pendency. If the child is to relocate, knows of any proceeding that could affect the current proceeding, none of that was complied with here, Judge. We would aver mother has unclean hands. She's done this to try to gain an advantage in this divorce proceeding. I know that's more of an argument for father to make in Colorado if that court tries to exercise jurisdiction over this minor child. But we would assert under 36-6216, A1 is not applicable, and therefore the court would have to go to A2, and we believe the court can exercise jurisdiction under A2. As a court of another state, neither Colorado nor West Virginia has jurisdiction in this matter with respect to making the initial child custody determination. With that being said, if the court does conclude today that the court has jurisdiction, mother has filed documents in the Colorado court saying she surrenders her rights to this child. Mr. Thomas is the biological father. He wants to be the father. He's got stuff set up at his house to be the father. He couldn't communicate with Miss Thomas because of the order of protection. She relocated out of state. He couldn't be there during the birth of this child. That wasn't his own request. He was prevented by law from doing that. So it's not like we have a person that's just intentionally not being present in this child's life. He was prohibited by an order that he could not be there. So we are requesting that if the court determines that it has jurisdiction, that the court issue an order, a temporary emergency order, transferring custody of baby girl Thomas, who's located in Colorado, to Mr. Thomas, which also brings significant concerns to the party's other minor child that is in mom's care, custody, and control. She relocated and he's had no contact. When he finds out, and I think they're going to say there was some knowledge about him having knowledge of an adoption proceeding, he was not, they didn't communicate, there was an order of protection. He has serious concerns about this other child that's in mother's care. When you take one child and put her up for adoption and you surrender your rights, that he doesn't know where this other child's located. He doesn't know what's going on with this child. So he has significant concerns about the mother's fitness to care for the other child as well. So we're asking the court to, if the court determines it has jurisdiction in this matter, to make the initial custody determination to award him temporary immediate parenting time with these two minor children.
All right, you and Mr. Thomas have a seat over here at the table. Let me hear from Mr. Kirby, and then we'll start.
Morning, Your Honor.
Good morning.
I'm coming into this court late in terms of this case, so I apologize about that, but I got hired and filed an agreed order for substitution late last week and filed a response to this motion. I was not present at what happened previously. I can't speak on that. But what I can say is this, that there was a statement made by opposing counsel in terms of Mr. Thomas wants to be a part of these children's lives. I think that would have been something that should have been considered prior to him domestically assaulting, sexually abusing, emotionally abusing the mother of these children at this point, to which he's not only pled guilty to the actual action, he's also pled guilty to a violation of the order of protection as well, and that's here. This is not something that is new for Mr. Thomas, as he has a background of domestic violence. He's actually currently pending a charge, I believe, in South Carolina for domestic violence against another individual. The allegations of which are that he threw items to include broken glass and attempted to strangle that individual. That is still currently pending. He is not a safe individual to have around. And he has made that clear. He has a history of drug use. We would say that he probably still is considering and taking those drugs. Obviously, with less than a week of me being on the case, I haven't been able to get everything together that needs to be together. I'm still getting the file together from not opposing counsel, but opposing counsel and previous counsel to come here before the court today. What we have here, though, is a question of jurisdiction, where it is undenied that this child has never stepped foot in Tennessee, was not born in Tennessee, was
Let
born
me
in
interrupt
West
you and
Virginia.
ask this question. Are you aware how long this case has been pending?
Correct, yes.
It was filed October the 3rd of 2025, and your client has made an appearance and has filed pleadings in this court, submitted to this court's jurisdiction. Would you agree?
Not as it relates to this child, no.
Well, when you say not as it relates to this child, so you're saying that a person can have a divorce case pending in this court that concerns the custody of one of their children, and that if she flees the state and goes to another state, has a child out of wedlock, or has the child there in that state, that somehow that robs this court of jurisdiction over the second child?
I don't think it robs the court of anything, because I don't think the court ever had anything to be robbed of as it relates to the second child. She didn't flee the state. She was, by agreed order, allowed to leave the state because of the physical issues that had happened within the party's marriage at that point. Mr. Thomas doesn't know her address because that address is protected based on the physical issues that had happened within the party's marriage at this point. So she didn't flee in any way whatsoever.
Maybe that was a poor choice of words.
No,
on my
I
part, so.
understand, Your Honor. As far as the jurisdiction of what we're looking here, I have no qualms that this court has personal jurisdiction over these two individuals as it relates to the divorce. I have no qualms that this court has subject matter jurisdiction as it relates to the divorce of these two parties. I have no qualms that this court has subject matter jurisdiction as it relates to the party's oldest child. I believe the name is Scarlett, if I remember correctly. I do have qualms that this court has jurisdiction related to the youngest child. And the reason being for that is that home state is defined as, if a child is less than 6 months old, home state is defined as the state in which the child is born. West Virginia is the state in which the child is born. We don't get to A2, as was being argued by Mr. Bellamy, because we don't get past A1. West Virginia was the home state. We cannot confer subject matter jurisdiction to this court. These parties cannot agree to subject matter jurisdiction to this court. We have had many cases previously where we have a divorce going on in one state and we have to bifurcate it to the extent that custody has to be decided by a different state. I've had issues where custody is being decided by one state and it's bifurcated where child support is going to be decided by a different state. We have those issues pop up continuously, and this would be yet another issue of that point. When there is a question of UCCJA, I believe the next step, I think what the court is required to do, is to communicate with the judge of that other jurisdiction. We know what that other jurisdiction is. My understanding after talking to my client is that there was an ICPC between West Virginia and Colorado for the purposes of the adoption. I do not have a certified copy or a copy of that to hand to the court today. Again, I apologize, I'm coming into this late. I know that. I didn't file a motion to continue this because I know the court wanted to hear about this part of it. But I think Colorado has the open adoption right now. Mr. Thomas has representation in Colorado for that adoption at this point. He has every right to litigate that adoption in Colorado. And the adoption, as we all understand, would also be covered by the UCCJA as well. Child custody includes the idea of adoption litigation. I think it is most appropriate and the best next step, and I think what is actually considered and required by the UCCJA for this court to have an in-camera conference with the court that is doing the adoption litigation in Colorado and then discuss it from there. I don't think this court has the jurisdiction to take anything away from Colorado. I understand where the court's coming from, I do. But I don't think this court has the power to say, Colorado judge, you've accepted this. You've accepted these documents. You've accepted this litigation. But me sitting here in Tennessee, I'm going to take that away from you. Whatever happens after y'all's in-camera review, we can deal with that afterwards. But right now, I think that is the next step. As far as the argument of this child needs to be returned, or shouldn't say returned, this child needs to be given for the first time ever to Mr. Thomas, there's a couple things I would say about that. One, my client hasn't abandoned this child in the sense of just not having any communications with what's going on or not caring for the welfare of this child. In fact, she is sending breast milk to this child on a regular basis to the presumptive adoptive parents in Colorado.
Why is she giving this child up for adoption?
This was a child, this would have been 5 children in her home at this point. She has 4 other children, including the oldest child that's at issue here. This child there was some postpartum issues. This was something that was discussed, my client would say, prior to the order of protection being in place between these parties. It would be my client's statement that the father said on many occasions, or at least one occasion, I should say, that he would sign the adoption paperwork for that child if she signed the divorce paperwork. That's not where we're at, and that's not what's going on. Say that they never had any idea of adoption, that's false. They had talked about the adoption as it relates to this child. Was he given specific notice? I can't say that. I wasn't on this case when it happened. I'm going to defer to Mr. Bellamy saying that he got specific notice only when he got served. That's the best explanation I have as far as that's concerned, Your Honor, where they've had communications with it. This was a plan from the beginning. These were pre-adoptive parents that in Colorado that had been a part of this pregnancy throughout, is my understanding of this. This was always the plan, is my understanding. As far as taking that child and giving it to Mr. Thomas for the first time, a couple things that I want to say about that. One, we have an older child that's not even seeing this father right now because of all the protective issues that we have in place. 2, we still have pending criminal charges. 3, we still have an order of protection that's in place right now. 4, when we get to this point of looking at that, the consent that was there and submitted by my client, it actually states in there that were that adoption to not go through for some reason, whatever that reason might be, whether it's jurisdictional or otherwise, that child will return to my client's care and custody. That's what the consent states. If anything, if something happens with that adoption, the point emphasis would be that that child returns to my client based under the essential contract law that has been entered into between my client and these adoptive parents. The other part of this that I would say is that there's nothing going on with Scarlett To say that there's an adoption proceeding there, that means that she's doing something with this older child is disingenuous at best. There's nothing that needs to be said about other litigation with Scarlett because there is none. If the court wants us to have a specific order stating that nothing will be done with that child, I have no objection to it because nothing's going to be done with that child. That child is with my client. That child's well taken care of. That child does not really even know father at this point based on everything that's been happening with this proceeding as far as the order of protection and protective orders that have been in place. Thank you, Your Honor.
This court is of the opinion that there is a fundamental difference in this case than in the normal UCJE Uniform Child Custody and Visitation Act cases. Number one, this case was filed in this court on October 3rd of 2025, and that was the complaint that was filed, so jurisdiction was invoked in this court. The court then conducted a hearing in front of Judge Larry Wallace in February of 2026 and entered an order regarding the custody, support, and so forth, which was again exercising the jurisdiction that this court had over these parties and the child that was born at that time. So what the argument that the defendant in this case, or actually it's the plaintiff in this case, actually the plaintiff was filed, a complaint was filed by Michael Thomas. The order that was drafted shows Rachel Thomas as the plaintiff, but I think that is incorrect. That may have been with the order of protection situation. In any event, the court entered an order that controlled the parties and ordered certain testing to be done for DNA. There was, I think there was an order for support and so forth that was entered in this court. So Ms. Thomas invoked the jurisdiction of this court to her benefit by obtaining an order of this court. Now she seeks to say that this court doesn't have jurisdiction over the child that was born simply because she relocated to another state. I am of the opinion that that does not prevent this court from having the opportunity to, or having jurisdiction to decide the custody of both children. To rule otherwise would encourage parties who are dissatisfied with the court's ruling on a custody case and they have a pregnancy involved and they simply move to another state and thereby make the argument that this court is robbed of jurisdiction because that child was born in another state. I understand that where children are, the Uniform Act provides certain protections that if a child is living in another state and that state is asserted jurisdiction. But this court has already asserted jurisdiction over the parties and their older child, and this court, part of what this court will have to do, whether it's me or another judge, is to make a determination as to the custody of that oldest child. Part of that factor will be the behavior of the parents, all of those statutory factors, and the factor of whether or not these siblings are together or apart, and what was her reason in placing this child up for adoption and so forth. So I'm of the opinion that the jurisdiction of this court extends to this young child that was just born, and that the Uniform Child Custody and Jurisdiction and Enforcement Act does not prevent this court from having jurisdiction over that child simply because Ms. Thomas moved to the state of wherever she's located in West Virginia or wherever it is, and then placed the child up for adoption in Colorado. Colorado's only jurisdiction over the child is because the child was brought into that state for the purposes of an adoption. And if the adoption is not valid because there's been no surrender of that child by the father, then in my opinion that court does not have proper jurisdiction under the Uniform Act either to do it. I think this court is the only court that logically would have the right to make those decisions. So I am of the opinion that this court, and do hereby hold that this court continues to have jurisdiction over the parties and the parties' minor children. The Colorado court obviously may take a different view, and there may be an extensive litigation involved in that. However, Mr. Thomas's request that this child be surrendered to him in view of all of the allegations that have occurred in this case is not something that the court will automatically take it upon myself to simply say, well, he's going to get custody of this child. He doesn't know the child, has never had any contact with the child, and the older child, there are certain protections in place because of the allegations of domestic assault and domestic violence. So it's this court's opinion, at least, that it is not an automatic thing that I can return this child to Mr. Thomas. The Colorado court's going to have to rule on whether or not they have jurisdiction. It'll be litigated there. I'm assuming that Ms. Thomas may choose to make an interlocutory appeal on my ruling regarding jurisdiction. If that's what she chooses to do, I would authorize that because I think it's a very unique legal question. In the meantime, Mr. Thomas's rights are protected against this court, at least under this court's order, from any surrender or any termination of his rights for failure to have a relationship with the child because he's attempting to do so, and this court is of the opinion it would not constitute abandonment that would result in a termination. Then that brings us to what are we able to do at this point other than my ruling that we have jurisdiction. I think it's going to require, before I can do anything about that child, we need to see what Colorado is going to do regarding their I don't think West Virginia is really the issue. Child's not there, being born there doesn't mean they have jurisdiction. So with that, Mr. Bellamy, do you have anything you wish to add about today other than the fact that I've reaffirmed my ruling? And we set this hearing to determine what the DNA tests were going to be. DNA shows he is the biological father. I'm therefore ruling that we do have jurisdiction over this child. If the defense wishes to seek an interlocutory appeal to a court of appeals for their interpretation, and I'm willing to do so, do you want to put on the record the circumstances of this so that there is a record made to take to the court of appeals? That would be the only thing I would offer.
Judge, just a few things if I could add briefly. The order of protection in this case, is the court saying that the order of protection extends to the newborn minor child?
I'm not saying that the order of protection extends to the newborn minor child. It extends to those people who are listed on the order of protection. The order of protection lists the mother and a stepdaughter, a stepson, and Scarlett Thomas, who is the child of these parties. It does not mention this unborn child. It was issued back in September of 2025, and therefore the child obviously she was pregnant with the child, and it could have mentioned that, but it did not. So I'm of the opinion it does not apply to that child. But asking me to order that the child be surrendered to Mr. Thomas in view of the allegations is what I'm simply saying. I'm not prepared to do that.
So I guess that would be my concern is when is the court going to be prepared to make that determination?
Well, I will give you an evidentiary hearing and you can make that argument, and then I will make a ruling, and if you want to do that today, we'll do that today. It's up to you.
If I may confer with my client just briefly, Judge.
Your Honor, as far as the evidentiary hearing, while he's conferring with his client on what he's been at like that, I'm going to respectfully say that any evidentiary hearing on that topic, I would ask to be continued to another date for many reasons, one of which I just got on the case, as the court all knows, and we've already said ad nauseum here this morning. Secondly, there are things that are related to what is happening with Mr. Thomas in his own personal life that I need to get proof of.
Mr. Bellamy, Mr. Kirby is right. He's new to the case, and I think under the circumstances, this is a unique situation. I'm of the opinion that I can give you July 22nd.
Give me one moment, Your Honor, let me check. I have a preview of the final hearing on July 22nd.
All right, well, my calendar in the month of July is full, but many of those are criminal trials. I've missed a call from General Lee Willoughby over in Cheatham County because I'd asked him about, are any of those. All of us who practice law know that just because it's on my calendar doesn't mean it's going to go. So bear with me and let me step off. I have a TBI agent that was supposed to be here. All right, he's here. And I need to see him about a judicial subpoena. Then I will check with Mr. Willoughby about that calendar, and then I'll let you know what we have available. My inclination is to set it for July, after you get Mr. Kirby an opportunity to be heard, or rather get prepared, and then we'll come back, so.
Understood. Thank
All
you.
right.
Thank you, Judge.
John, would you entertain an announcement?
Sure. You want to make an announcement?
Pass the motion on Dunham to get the parties to mediation. And that's really all that the announcement is for today.
So, Ms. Byrd, you act like you've got some other place to go.
No, I love being over here, Your Honor.
All right, so you're just going to pass this, is that
Yes, Your
correct?
Honor.
It's fine. We'll show it passed. All right, we'll stand in recess for a few minutes.
All right. Court is now in recess.
After speaking with the district attorney, I have offered I can give you the 16th of July.
And depositions all day that day, Your Honor.
I can give, what about the 15th of July?
I have a dispositional hearing that day.
You have a hearing?
I do.
Did I suggest the 22nd of July already?
You did, and I had a hearing on that one.
What about the 29th of July?
29th would work for me.
I'll make it work, Your Honor.
All right, then we'll reset this matter for the 29th of July. And at that point, hopefully we may have some sort of ruling out of Colorado. Does anybody know what their status is regarding this situation?
I was going to ask my client, but I don't see her on the WebEx anymore. I didn't want to step out and call her.
You may, she's exited the hearing, so.
Okay. I don't have one off the top of my head. I know that the last update that I got was that Mr. Thomas had hired counsel. I would assume there's a motion date, but I would need to check with the counsel in Colorado to see what their next
All
date
right.
is.
And Judge, that would be the update I've got to provide as well, but just some clarity for the record is the court has stated that it's exercising jurisdiction in this matter over this minor child.
That is correct.
But is the court saying,
That's the day I'm
Further-
going to, I'm sorry.
you're
Go ahead.
ahead. Is the court saying any further determination regarding the minor child is dependent on the outcome in Colorado?
No, but I'm saying that it would be good to know what Colorado says, so, you know.
Understood, but just for the record, this
I am
court's
of the
exercising
opinion-
jurisdiction and it's not contingent on
I'm of the
Colorado's.
opinion that Colorado has, the right to decide whatever they want to decide. I'm going to rule that we have jurisdiction over this minor child. That doesn't mean your client's going to automatically get this
Certainly,
child.
certainly.
It will be a factor that this court has to determine, and I have to have an evidentiary hearing, and that's what the 29th is going to be about, is a custody hearing over this minor child that I've said we have custody over, jurisdiction over. And the defendant in the case, Ms. Thomas, will be able to present all of the evidence that they claim. All I've heard have been allegations. And that hearing will be for the evidence to be introduced that allows me to make a decision, and I will consider all of those factors set forth in that. In the interim period, obviously, Mr. Kirby may decide he wants to pursue an interlocutory appeal on the jurisdiction issue, and I'll leave that up to him to do that. So. But right now, I'm setting the Thomas versus Thomas on the custody issue over this minor child and the visitation with the other child as well All of that will be subject to a hearing on the 29th, so both of you marshal your evidence, so. All right.
Understood.
Thank you, Judge.
Thank you very much.